Thank you, everyone. Please be seated. Thank you to our staff for helping make this transition between cases. It's greatly appreciated. Our third and final oral argument for the morning is State versus Taiwan Tucker.
May it please the court. As I went back and was preparing this case for oral argument, I went back and looked at the September oral arguments, and I looked at the oral arguments set for this October. Then I went back to the Dame case. And I think it's not lost on anybody preparing for oral arguments that this court is granting cases where there's been guilty pleas or sentencings to possibly address the 814 statutes and their amendments. And so for our argument in this case, we raised 3 issues on appeal, but I'm going to focus on our first one under the good cause requirement, because I'd ask this court to invoke the rule that when there's an involuntary guilty plea during a guilty plea that violates due process would be the claim that equals good cause. And in this case, we believe good cause is established when the court looks at the record. When the court looks at the record in this case, the sentencing transcript and the plea transcript, all done in the same day, does not start out with a lot of confidence it was going to be successful. As you read the transcript, as a court comes into the courtroom and says, hey, tell me what's going on, prosecutor goes, hey, we're going to enter a guilty plea today, and here's the plea agreement. And defense counsel says, well, I had a brief conversation with my client, and he wants to enter a guilty plea today. Then the court starts the guilty plea. He swears my client in. And he says, okay, Mr. Tucker, I got to swear you in. He's sworn in, and my client says, why do you have to swear me in? So I have to stretch the truth? And so that should have been the number one key in this case, that it had to be stopped. And to figure out why Mr. Tucker would have to stretch the truth in order to lodge a voluntary and intelligent plea. When the court looks at the record too, they'll see that this man was indigent, was in jail, had a $5,000 cash bond. Also, that 8 days earlier, Judge Kelly in Polk County had given him a suspended sentence on a different case. So we have this young man, not young man, he's in his 40s, waiting to get out of jail on his suspended sentence on his prior case. The court can see the toll it was taking on him.
Mr. Dunn?
Yes, sir.
Did you watch the prior argument regarding the factual basis?
Yes, I did.
Assuming that's true, and then you're saying good cause is where a guilty plea is not knowingly or intelligently made, voluntarily made, what defects of plea proceedings would not constitute good cause? Because it seems like the request is going to be every defect in a plea proceeding should be good cause within the meaning of the statute. So what defects would you say would not constitute good cause?
I can only answer what defects would constitute good cause, because otherwise, if it was a good cause, they'd be frivolous. And I can't think of a guilty plea that I've challenged which has been so frivolous that I said you just can't do anything about it. So I don't know, maybe I'm not understanding the court's question.
I think maybe, but I guess that my question is it seems like the legislature passed this statute for a reason, and they wanted to limit appeals from guilty pleas as a matter of right. But it seems like all of the exceptions that are requested would just return us to the status quo, right, of what we had before the enactment of the statutes. Is that fair?
In the legislature's view, possibly, but not in a judicial view, when the court knows and the attorneys know that mistakes happen during guilty pleas, that people are forced into pleas they don't want to take so they can get out of jail, that they're forced into pleas because they're indigent and they can't post bond. Yes, I understand why. I think everybody understands, the idea behind the statutes, but they don't fit in to case law and precedent and what we expect from the sanctity of a guilty plea.
Let me ask this question. Perhaps someone could say that it's not entirely clear on this record that the guilty plea was involuntarily made. I have looked at it, as all members of the court have, and there's some features that are irregular, I'll say, and that really raised some questions. You pointed out one already at the very beginning, brief consultation and stretch the truth, and et cetera, et cetera. But yet we don't know precisely what was talked about by the lawyer and the client, either at the plea hearing or prior. It may well be that this client was a sarcastic individual, but the lawyer at PCR might say, well, you know what? We thoroughly discussed everything. The conversation was brief. Yeah, it was a brief 20 minutes, and he was adamant. I mean, it's not 100% clear to me on the record that we can resolve this case, and maybe we do need a PCR on it.
So I would say my response to the court, that still doesn't get us around having, or this court getting around having to answer whether an involuntary plea raised on direct appeal through a record that points to an involuntary plea satisfied good cause. Like in the Dunn case, when this court took really a twofold approach. They said, what's good cause? And then the court wrote a legally sufficient reason. And then they said, well, a legally sufficient reason is if the court looks at things outside the record or improper factors when imposing a sentence. Then this court said, first, legally sufficient reason, defendant, you have that. You're raising a sentencing error that's based upon the court's discretion. Secondly, let's reach it. We can reach it on this record. We don't think that the court abused his discretion or considered an improper factor, and we're going to affirm the district court. But then I think the court can also go back to the Weitzel case a few years earlier when the court's looking at whether or not there's a rule violation or a due process violation when the defendant is not instructed that they were going to pay a surcharge as a maximum fine in the case. And this court said, know what? We're not going to go through a bright line rule of deciding whether or not what motivated a person under a due process challenge to enter a guilty plea. Because there's many factors.
If I can just return to my question briefly. I'm not 100% sure that a legal issue is raised here. I mean, I understand the theory, of course. I understand involuntary plea and all this, but I don't know that it is established as a matter of law based on the record we have here that the guilty plea was involuntary. There's plenty of smoke, and there's plenty of reason to raise the judicial eyebrow. But if we were to deal with this case on direct appeal, it's really got to be clear as a matter of law. Number one, do you agree with my analysis? Number two, is it really a matter of law?
Yes, to some extent, I agree with your analysis, but I have to qualify it in that I think it's a twofold approach. The court can decide whether or not an involuntary plea raised on direct appeal is good cause. Second, the court can decide whether the record is sufficient to reach the ultimate issue. If this court says we got to send this back to PCR to hear about that discussion right before the guilty plea, we want to hear about Mr.
So are you saying, Mr. Dunn, that any assertion that a plea was not knowing and voluntary, that assertion constitutes good cause? Now, and we'll entertain the appeal. Now we might decide to preserve the matter for PCR because we don't have enough record. But you're saying that any such assertion constitutes good cause?
I would say the assertion that the guilty plea was involuntary in violation of due process is good cause. And there's also an onus on us attorneys not to raise frivolous claims on appeal. So to think that we're going to be...
But doesn't that get back to Justice McDonald's question then, kind of what did 589 do if that's the case?
We know what it tried to do, and I can only speak to the legislature. I watched the video too when they're talking about, when the one man is talking about saving resources. I wish he would have said, And I don't know what he did or didn't do. I wish he would have said, you know what, I met with district court judges, I met with magistrates, I met with associate district court judges, I met with some of the justices on the Court of Appeal and Supreme Court, and they're saying, hey, you know what, we need to tighten the ropes on these issues. But I didn't really hear that. I heard him reference a judge once, I think, at the very beginning. So I don't know.
Well, Counsel, when we said in Dame, the good cause is context specific, and we expressly left open the question of what good cause is required to challenge a guilty plea, made clear the sentencing error is different and allowed that if there's a legally sufficient reason. But shouldn't we have a tougher, a higher burden to show good cause to challenge a plea if the legislature, the whole purpose of the statute was to enforce the finality of guilty pleas, to reduce the number of appeals from them?
I think that would only be the case if you're lessening the value of a guilty plea with respect to what happens at sentencing. The guilty plea through case law, as I indicated earlier, there's a sanctity there. We want it to be true. We want it to be voluntary. We want it to be intelligent. We want it to be without compulsion, without a desire to get out of jail, without other desires. We want it to be pure. Okay. After this, once we're at sentencing, the pureness of it's all done. You know, and then, you know, as we talk about a motion and arrested judgment, and maybe I'm moving away from the Justice Waterman's questions, and I apologize, but
Follow up with where you're going on the motion and arrest.
please.
So I agree with everything you said regarding the integrity we want with respect to guilty pleas. My question is, why can't that be addressed on post-conviction relief, as the legislature suggested? And then two is, if I recall correctly, in your main brief, you did not request that we adopt plain error review. And if that's the case, then why doesn't Rule 2.24 and your client's failure to file a motion and arrest of judgment bar this claim? And if it's barred, there's no legally sufficient reason for good cause, right? We can't provide relief.
The answer to your first question, yes, I understand that PCR is used to flesh out and make the record that's clear through all the time. The only problem would be that if a person can't post bond on a PCR, if they have a challenge to a factual basis or an actual innocence claim, you know, some appeals you're able to post a bond on and some you're not. So I believe in this case, if Mr. Tucker was sent to jail on this case, I would be able to post an appeal bond. Then again, he has to have the money to post the appeal bond, and which he doesn't because he's indigent. I'm court appointed on appeal, so he's going to be sitting in jail or in prison while his PCR case is going when he's saying, hey, I didn't voluntarily plea. Secondly, going back to the court, no, I didn't raise plain error in our appellate brief. I don't think I'm precluded under the motion and arrested judgment for these reasons. Clearly, it wasn't filed. First, I think the court has to look at a motion and arrested judgment that it's highly unlikely that the same attorney who did the guilty plea, in this case, court appointed, he did the guilty plea, is going to file a motion and arrested judgment before sentencing saying that, hey, I allowed my client to do an involuntary plea. It's not practical. I apologize, it's not. I don't see that happening. It's usually you have to get another attorney to come in as what happened.
I agree with that, but
Okay.
why isn't your client barred? That's what the plain language of the rule says.
And the reason that we're not barred, it goes back to the reason why a court on direct appeal will look at a guilty plea for voluntariness or other factor when the court doesn't advise the defendant he has a right to file a motion and arrest a judgment. And this is how it applies to this case. This judge didn't explain to Mr. Tucker what good cause is. He also didn't explain, he said, hey, you can only take away your guilty plea. I mean, you can only appeal now if you have good cause. He didn't explain what good cause is. Also, he didn't explain to Mr. Tucker that, you know, this very special language that's in 814.29 that, hey, Mr. Tucker, I have to advise you of something. Your plea will not be vacated unless you demonstrate that more likely than not, you would not have pled guilty if the defect had not occurred. He was not told that. You know, that's powerful language to a defendant when he's entering his guilty plea. Oh, by the way, I got to let you know something. This plea is a lid on the box, which I know what this court, what the courts want on guilty pleas. They want it to be done. We all want it to be done. But if we tell the client, hey, by the way, you can't come back and say, hey, I didn't want to, because you have to prove it's more likely than not that
I
you
guess I
wouldn't
don't
have-
follow. It seems like the district court's advisory here was even more certain than what you're suggesting. The district court said, if you don't file this motion, you are forever barred.
But-
Done, closed, no exceptions whatsoever. That seems to me much more definite than what you're proposing. And I guess I don't understand why that bar would not apply.
First, the bar is more problematic. I see my time is up, if I may finish.
You may finish.
Okay. Here, he entered his plea and sentencing on the same day. So obviously, there's a special waiver there. I mean, that could go into the voluntariness. Secondly, I think the courts now have an added obligation to let them know the restrictions of 18.29, saying, tell you what, you don't only have, number one, you can't file a motion to register judgment. You're going to have a lot of trouble ever saying that you made a mistake here or this wasn't voluntary. Secondly, by the way, if you appeal this to say that this plea wasn't right, you got to prove it's more likely than not you wouldn't have done this. And so you need to be aware of those factors. So I think these are extra components that are placed upon judges and attorneys now based upon the statute, and that wasn't done for him in this case. For these reasons, Your Honor, I'd ask that the court find that his plea, based upon the due process violation, is good cause for the court to consider, and ask that I think enough is there to say, hey, we want to send it back and let him withdraw his guilty plea and let the case go forward. Thank you.
Thank you, Mr. Dunn. Mr. Buller?
May it please the court. I think in some ways, this case is simpler than it appears on first blush. There's a lot of talk today about good cause and what good cause means, but the court doesn't need to answer that question here because the only issue presented by the defendant requires this court to engage in an ineffective assistance analysis. That analysis is expressly barred on direct appeal by 814.7, regardless of how the 814.6 question is answered. So the long and the short of it is you can set good cause completely aside for purposes of this appeal, because even if this case is properly before the court right now, the only issue the defendant has put forward can't be decided, and that disposes of this case. I want to talk a little bit about what the court's questioning finished up my opponent's argument regarding with that advisory and whether or not 814.29 required anything additional. 814.29 really isn't a dramatic departure from Hill versus Lockhart. That's a 1985 case. So 35 years, this has been the state of the law for an ineffective assistance claim that challenges a guilty plea. This court expressly adopted that standard in the Straw case about 15 years ago. This isn't a new issue. This has been the state of the law for a long time, and this court, either through its case law or its rulemaking function, has never required a defendant be advised of the legal standard that will be used on a claim in ineffective assistance. And of course, if we're going to require a district court to advise the defendant about the legal standard for every potential claim he could ever make regarding a guilty plea, we'd have 10-hour colloquies and the courts would grind to a halt. That's not realistic. I think what we have here is a colloquy that really did go above and beyond what the district court judge needed to tell the defendant. File that motion and arrest or you can never raise the claim. And then the district court, in advising the defendant about the notice of appeal, expressly mentioned good cause. Now, the defense has complained today, well, he didn't say what good cause is. Well, this court hadn't at the time either. I don't think we can fault the district court judge for that. The court,
well, let's talk about what good cause is. It's a ambiguous term, it seems to me. It's context specific generally, meaning you look at the statute and try and figure out, what its contours might be. But it seems to me if we're textualists today, we just look at the statute. We're not purposefulists. We don't look at the possible underlying purposes. We look at what the legislature did, and the legislature established a good cause exception for certain guilty pleas. It used broad terms. B, it's for the court to decide what good cause is. And C, it looks to me like it's a clarification of our current law, or there's an argument is it's a clarification of current law. We don't consider guilty pleas on appeal unless there's good cause to do so, namely they present crisp legal issues. So on the good cause piece, at least, why can't we just regard this as a embracing current law?
I think there are a number of pieces to your question. Justice Appel, I know you'll bring me back if I don't address them, but the first I want to address is whether the legislature was codifying existing law by enacting SF 589. In fact, the legislature...
No, just a good cause provision. I understand some of the other provisions weren't just codifying current practice. They weren't at all. But on good cause, maybe.
This court's case law has repeatedly said that you can't look at two words in a statute in isolation. But even if that is what you were going to try to do here, the placement of good cause in 814.6 does not suggest a codification of existing case law. Existing case law permitted appeal as a matter of right from every final judgment of sentence, whether it was a guilty plea or a trial. The legislature expressly rejected that approach for guilty pleas by amending 814.6. They turned the general rule into a rule in which the defendant bears the burden to establish good cause. They flipped the existing legal standard on its head. I don't think there is any credible argument that 814.6 or any of the other provisions of SF 589 were intended to codify this court's case law. In fact, it appears to be the opposite. I think whether you're a textualist, a person who looks at the purpose of the statute, or whether you employ all of the canons, which has been this court's general approach, you have to look at the context in which the legislature has acted. SF 589.
And isn't there good cause when a crisp legal issue is presented in a guilty plea context? Why bother with PCR?
Well, I'm not sure what crisp legal issue means, but whatever it is, it's not this case. Here we have 10 off-the-record colloquies between defense counsel and the defendant. There are, I would admit, some unusual exchanges in the plea transcript, but of course, pleas are taken by imperfect people. Judges are imperfect, the lawyers are imperfect. Certainly the clients and defendants who appear in front of the judge are imperfect. It's not unusual to see a defendant mouth off to a judge, which does appear to be what happened here.
Yeah, I may be with you. I may be with you there. I understand those issues, but if the majority of the court were to agree with you on this point, the matter gets sent to PCR for factual development. That makes complete sense. But where there's no requirement of factual development, why shouldn't we consider it on direct appeal? That's good cause to consider it. It'd be a waste of time to send it down to PCR. We got the case. Let's decide it.
Well, again, even if you were to find the good cause was presented here sufficiently for this court to have jurisdiction over the case in the first place, the only issue raised by the defendant is an allegation of ineffective assistance, and that is expressly barred by 814.7. And there is no constitutional problem with 814.7. This court is one for the correction of errors at law under such restrictions as the General Assembly may by law prescribe. They have by law prescribed a restriction on this court's authority to hear that particular claim in that fashion. And I want to be clear, that doesn't mean this court never gets to hear an ineffective assistance claim. You hear a lot of them, and you will continue to do so through the context of Chapter 822 post-conviction relief. And the defendant there does have appeal as a matter of right. So if there is anyone in the room that has heartburn about taking away this appeal as a matter of right, that isn't going away for the defendant. All the legislature requires is that these claims be first raised in that post-conviction case, which is consistent not only with what this court has said in the past, ordinarily these claims require that development, but also with what the legislature has done. The state of the law used to be that you had to raise these claims on direct appeal, whether you had the record or not. In 2004, the legislature acted to say you could raise the claims, but ordinarily they're going to get preserved and the court has authority to do that. What we see
Counsel, did you hear the previous argument? You probably did. Were you able to listen?
Yes, I was.
Yeah, okay. So I just want to follow up on something that was developed there a little bit, and that is, well, a good cause must mean something, of course. And the notion was that kind of the label that was used was, well, maybe in some exceptional circumstances, good cause might exist in a guilty plea. And as you may remember, I was kind of exploring, well, and I'd like to invite you to do the same. You heard the suggestion, and I'm not trying to get you cross-faced with your other counsel. What I'm trying to do is just kind of figure out, what the depth is of this admitted exception to the general rule that the legislature's provided us. So please go at it.
Sure. I think the state's briefs are consistent. Extraordinary circumstances is the language that we suggest should be used to interpret good cause. But of course, these briefs were filed before the court decided the Dame case. I recognize that is controlling. The court there drew what I think is a fairly clear line between challenges that are to the plea itself versus challenges to open sentencing when there isn't a joint recommendation from the parties. So for our purposes today, I freely admit Dame controls. We're not challenging that here today. But the problem with the argument you hear from the defense is what they want good cause to mean is something to get every claim they want in front of the court past the statute. If this court were to hold that, it would not only be inconsistent with legislative intent, it would defy the legislature's intent in passing SF 589. Good cause does have to mean something. In Dame, the court says legally sufficient reason and offers a specific example of an open sentencing in which the defendant challenges, for example, an abuse of discretion or an improper use of factors by the judge. What it cannot mean is that the defendant gets to raise challenges that are expressly barred by other provisions of the code. That's what the defense wants you to hold today, that good cause is so wide and sweeping that you override the legislative judgment in other provisions enacted in the same bill so that he gets to raise his claim here. Again, that would not only be inconsistent with legislative intent, it would outright defy the legislature by making section 814.7 a nullity and reading out the amendment to 814.6 for discretionary review following a motion and arrest of judgment. If those
help me on part of that. The section on guilty plea says that there's a good cause exception. The statute then has this provision with respect to ineffective assistance of counsel, which you're relying on to some extent. But is it possible that there could be a good cause to consider a guilty plea, even where there was ineffective assistance of counsel? You're assuming that the ineffective assistance provision means that you cannot ever have good cause where ineffective assistance is present. I think that's your position, and I'm not so sure that's right.
Well,
do you see what I'm saying?
I do, Your Honor, and I disagree. The language in 814.7 is very explicit. The claim shall not be decided on direct appeal from the criminal proceedings. It's hard to imagine how the legislature could have been any more clear with 814.7.
Except then they say good cause. I mean, they say you can have a guilty plea. You can appeal a guilty plea if there is good cause. It's just not clear to me how the provisions interrelate.
And I don't think it's that complicated. Whatever good cause means, it can't mean bringing a claim that is expressly barred by another provision of the statute. And I don't think 814.7 would be the only example. There have been questions today about 2.24, the rule of criminal procedure. You can't bypass the requirement of filing a motion and arrest by just throwing the words good cause out on direct appeal. This court would have to overturn its case law, probably abrogate its rules, and act in defiance of the statute to reach that kind of claim. I admit to some extent there is flexibility to the term good cause, but there are outer bounds, and the issue raised here is far outside the bounds of what good cause could tolerate under even a creative or far-reaching definition. There's been a little bit of argument by the defendant regarding 814.29 and the lack of advisory should be some kind of exception to that. But of course, the first time we've heard that argument is today, an oral argument rather than the briefing. And I think it's directly contrary to what this court has said time and time again about the necessity of filing a motion and arrest of judgment. This court prefers to resolve preserved errors. There is no plain error in this state. This court has been resolute in rejecting plain error in this state. And in many ways, you see that that is what the legislature has codified here. If there's a preserved error in the motion in arrest of judgment, you can raise that on discretionary review to this court. If the error is not preserved, we're usually going to need additional record. So much like this court has suggested and much like the legislature has said, that claim shifts to post-conviction relief. And I want to talk just briefly about...
What is I guess I disagree with that a little bit in the sense that I think Justice Mansfield's written about this before. We've just used ineffective assistance of counsel as a plain error standard, essentially. I mean, to excuse error preservation. So what would be the practical reason, for example, why we would not want to look at a factual basis challenge on direct appeal? That's just a purely record inquiry.
Factual basis is a more difficult question than what's presented here. So with the admission we're drifting off the briefing, I'll talk in generalities. I think there are good reasons to have that factual basis claim go to post-conviction relief. As this court has recognized, and as Ms. Lucy said earlier, the remedy in these cases is to give the state the opportunity to develop that factual basis. It's more efficient to have that done in front of one judge in the post-conviction court than for this case to go up in front of 7 justices here or 3 judges downstairs, then to have it remanded to be put back in front of another district court judge to make the same determination a single judge could in a post-conviction case. Now, some PCR cases have historically moved slow in this state. I'm not going to dispute that. And I think there's blame to go around between defense lawyers, the court, scheduling. Sort of everyone has treated these as being on the back burner at different times. But that doesn't have to be the case. If you've got a clear-cut factual basis issue, there's an element missing. It's a slam dunk for the defendant. File that post-conviction action, file a motion for summary disposition, which is basically summary judgment for a PCR. You don't need a PCR trial. You'll get relief if the uncontested facts in that application would require the plea to be vacated and the state to be offered the opportunity to supplement the factual basis. One judge, one hearing versus a series of appeals, the potential of further review, something like 18 months, a remand to the district court, and then them getting that same remedy. Post-conviction is going to be faster for that kind of claim than a direct appeal and the extended process here would. I see my time has expired. I'd ask this court to affirm and hold that all of the relevant provisions of 589 are constitutional.
Mr. Dunn.
Thank you, Your Honor.
I want to ask you a question bouncing right off of what Mr. Buller said. Typically, when a PCR gets filed, if there's a motion for a summary judgment type proceeding, it's made by the state. What did you think of his argument about defense counsel making that to correct it and move it through the system quicker? Is that practical?
I'm sure some defense counsel would file a motion for summary judgment, and I'm sure some state attorney would resist it and say that under the summary judgment standard of review, which I didn't refresh my memory on that today, but I think it's rather minimal whether or not there's a disputable issue. And so the district court would probably say, hey, we got a disputable issue here. Take your depositions, submit them to the court. We can do a hearing. I don't think it'll happen that fast. And I'm also more scared about the defendants that are in prison and have to go through their sentence and their plea because they can't post bond or they have a non-bailable case. I'm concerned about that. I don't think it will happen that fast, but I mean, in a perfect world, it could. And then I don't think also I'm arguing that the good cause requirement can be anything fanciful or creative a defense counsel or a defendant can think of. The good cause comes through this court's, maybe the gateway of Dame. When the court looks, was its first chance to look at 814.6 and 0.29 and 0.7 saying, tell you what, good cause is legally sufficient reason. And guess what? A legally sufficient reason is based upon the case law we've already told you about.
If that's correct, can you directly address the state's argument that the only claims you're presenting here are ineffective assistance of counsel claims? Is that correct?
Yes and no. Okay. Our first issue is that it was a due process violation. stand still. I mean, a standalone due process violation. He should get a chance to withdraw his guilty plea because he felt he was compelled. I mean, that's the argument as we're pointing through that. And then we go through the backdrop of the case law at the time, saying the only way to get this through, since there was no motion to arrest a judgment and his plea and sentencing were on the same day, and it was with the same attorney who really can't file his own motion saying it was ineffective, we believe through that, that's the good cause to come to this court.
But it's because of that, because he was ineffective.
Yeah, and then the court.
So my question is if 814.7 says that appellate courts cannot resolve ineffective assistance of counsel claims on direct appeal, how can there be a legally sufficient reason to pursue the appeal when we cannot grant the relief you're requesting?
The good cause can be, I believe what Justice Appel was referring to, ineffective assistance of counsel under the realm of how the court has developed ineffective assistance of counsel claims over time, is if the record is sufficient enough.
I understand that.
Okay.
But what you're saying is despite 814.7, we can still decide claims of ineffective assistance of counsel.
Under the good cause.
Read statutes together. We read this as a whole, and if good cause is a legally sufficient reason, but 814.7 says ineffective assistance claims have to go to PCR, then that's not a legally sufficient reason if you read them together. Seems like good cause has to come from something that isn't based on an ineffective assistance claim.
And then through case law, we know that faulty guilty pleas are based upon an inadequate factual basis. That's through case law. We know that inadequate guilty pleas are based upon when the defendant is advised of or not advised of mandatory minimum and maximum sentences. We know through case law that if there's a breach of a plea agreement, the defendant can go back and withdraw his guilty plea. We know that an involuntary plea, a defendant can go back and withdraw his guilty plea if a defendant wasn't competent at the time. So these are all factors that can be a legally sufficient reason that support good cause. Because you guys have laid them out.
Maybe I'm, and I signed on to DAME, but maybe I'm alone in this, but I see that legally sufficient reason as kind of just circular language that doesn't really define good cause. I mean,
I would say
what really defined good cause for purposes of DAME was where we said you could challenge a sentence. Clearly, if there's no good cause, there's not a legally sufficient reason, and if there is good cause, there is a sufficient reason. At least when I signed on, I thought it was just kind of boilerplate, to be honest.
yes, and legally sufficient reason, the court said legally sufficient reason, but then the court explained what a legally sufficient reason was in a sentencing context. In the sentencing context, the court cannot consider an improper factor or rely on things outside the record. Therefore, through our case law, we know what a legally sufficient reason is at sentencing. The court.
No, but actually, we said we would entertain sentencing appeals without, on the grounds that that they met the good cause requirement, without first deciding whether the appeal was valid. We said, as a group, there's good cause in that area.
I agree, and based upon the foundation that through our history, we've noticed it's a discretionary sentence. So, yeah, I'm just making it more singular, specific. I'm saying the same thing can be done through a guilty plea proceeding. Through the foundation of the law, you've recognized things can go wrong with a guilty plea.
True, because we can resolve most sentencing challenges outside the framework of an ineffective assistance of counsel claim.
I see my time is up. May I finish?
Yes, please.
I agree that most sentencing issues, the court can look right on the record to make that issue. And I also would agree that on guilty plea proceedings, you can look at the record and see if there's a problem there. This is clear as you can a sentencing issue. So for those reasons, Your Honor, thank you for your time. I would ask that the court reverse and remand the district court's order in this case, allow him to withdraw his guilty plea and plead anew.
Mr. Dunn and Mr. Buller, this case is now submitted to the court, and we will adjourn for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.